Board of Appeals officially call the meeting to order. Time is 7:01. If you could first please rise for the Pledge of Allegiance. Okay, next thing we need to do is just confirm the next meeting date, which would put us at September 26, 2023. Do any of the board members have any conflicts with that date?
You said 26?
26th, the next meeting date.
Good for me.
How about, should you guys be needing Marguerite with that? I don't know if we will, but hypothetically, would that work for you?
That would work for me.
Do any of the applicants here tonight or any of the agenda items, would that work for anybody if needed to appear again? Any conflicts? Nope.
Works.
Okay. So just to start off, we will be taking one of the agenda items out of order today. Ferrer Development Group, LLC. They are currently listed as the fourth item agenda, but they need to they have another thing going on tonight, so they asked if we can move them out of order. So I would just need a motion to take the fourth agenda item, so 4A, item 4, to the top of the list for tonight.
Mr. Chairman, I make a motion that we move agenda item number 4 to item number 1 on the discuss and act for tonight.
Is there a second?
Second.
Any discussion? All in favor? Aye.
Aye.
Okay, so for those of you guys who don't know, this is the Center Street nursing home application that came before us. During the writing of the decision, Marguerite came to some information that she wants us to address. So she's here tonight to start off with that information. So whenever you're ready, Marguerite.
Okay, thank you. I received a request to write the written decision, and in that, I know prior to that, Attorney Fredericks had submitted a memo of law for the last zoning board meeting, and so I had a chance to review that as well, along with doing some additional research based on that memo of law and the decision. There was an additional appeals court case that came about after some of the cases that Attorney Fredericks had cited that addressed an element that wasn't fully vetted in Attorney Fredericks' memo of law. It addressed the idea that cessation of a pre-existing non-conforming use for a period of 2 or more years on an objective basis could be a way to eliminate that protection of the pre-existing non-conforming use status. And so I reached out to Attorney Fredericks to ask him to provide further research and for a further memorandum of law about that. I also reached out to Town Council to discuss that. I did draft a zoning decision for the board to review if they wanted to do that. However, I feel compelled as Town Council to point out that this seems to be an area that the board hasn't fully vetted or addressed. My advice would be that because this is the next meeting following your vote, that there be a motion for reconsideration of your vote to allow you also to, did you move to close the record, the public hearing?
They closed.
Yeah, also a motion to reconsider closing of the public hearing to allow you to take more information into the record, particularly on the issue of non-use. I think that I've seen a second memo of law from Attorney Fredericks. I think he's prepared to address this. I think there is information that exists that will be very important for the board to have in its record on this case, and that hopefully the board would be able to make some findings of facts based on that information, and then ultimately take a final vote on their decision, and I could update or revise what I've drafted if that's the case. So my recommendation is that you start with the motion for reconsideration of both the vote of approval and the closing of the public hearing, and that if that's approved, that you allow the developer an opportunity to present more information, and then you make additional findings of fact and you take another vote tonight.
And we would do the same 3 voting members, correct?
Yes.
And so Carrie, I know it was myself, Greg, and John, correct?
Yes.
Okay. Okay, so that being said, is there a motion on the floor to reconsider our vote for approval for Ferrer Development Group LLC.
Make-
Okay.
Go ahead.
I'll make a motion that we have a motion to reconsider for the Ferrera Development Group LLC.
Is there a second?
Second?
Any discussion? All those in favor?
Aye.
Now we need a second motion to reopen the public hearing for 907 Center Street.
I'd make a motion that we reopen the public hearing for reconsideration for 907 Center Street.
Is there a second?
Second.
Any discussion? All those in favor?
Aye.
Okay, so we can now discuss the new material that came before us. Do you think it's best to have Attorney Frederick start off with his findings?
I think that makes sense. Yep.
Good evening again.
No.
So when we last left this, there was a question of whether or not Marguerite should review it. What had happened functionally was she emailed me, she returned from her vacation on the Friday I left. So when I got back yesterday, I went through her emails. She was pointing out one particular case. It's the Bartlett case. It actually involved the zoning board in Freetown, Lakeville. And basically what that case goes on to do is look at, and it's in your bylaw as well, that it goes not just to abandonment, but also to the issue of discontinuance or cessation. In other words, they just stop using it. So the abandonment issue is more of a subjective test. Was there intent to abandon, those sorts of things? That's what I had previously briefed. The cessation, the did you stop using it, is more, as counsel said, an objective test and something that's a little bit more bright line for a board to use as its criteria. I don't think it affects the analysis in this case whatsoever. So I submitted a written memorandum. I went back, I took a look at it. And I added some to the fact section of the acquisition of the property. So the property was originally owned by Center Street Realty SPE LLC. There was a larger company that owned 5 or 6 nursing homes in the state of Massachusetts. It's that larger entity that lost its license to operate as a nursing home. That happened in approximately 2019, and that's what the Board of Health records reflect. But that's just because they lost their license, people didn't vanish. They then had to start arranging for people to transfer out of the facility into other facilities. There was also a major problem. Almost as soon as they lost their license, COVID came in. So if you're familiar at all with what COVID caused as far as the nursing homes, it was a devastation to nursing homes. Nursing homes closed their doors. They wouldn't take new patients in. I had a situation in my own family. I was trying to get my uncle into a nursing home. It was impossible. So the long story short is you have multiple events affecting this situation all at the same time. I had occasion to try to speak to some of the abutters. I had heard that it was possible that some of the patients there were present on the property until 2021. And in asking the questions, they couldn't give me specific dates, but they said yes, in fact, they felt that that was likely. So now we have a situation where you have people on the property that can only be there because they're being treated as nursing home patients in through to 2021. So that's the operation of the property. Now, if you take the step back and you look at the documentation that we have, the company that I spoke of, the Center Street Realty SPE LLC, went through a bankruptcy. They lost their license, they couldn't operate their business. It's fairly obvious that they'd have to. As they went through the bankruptcy, the courts, just like the rest of the world, experienced the COVID stop. So their bankruptcy, their stay in bankruptcy, all of those things were extended and extended and extended. Not until the spring of 2022 was their bankruptcy concluded. That's backed up, and actually, I apologize. I actually referenced in my memorandum a certificate of entry, and I have those for the board. Marguerite, I have one for you as well.
Thank you.
What a certificate of entry is that's the moment that somebody else takes possession of the property. So once the bankruptcy concluded, then the mortgage company went forward with the foreclosure. By the date of that, it's June 27th, 2022. So the only time that the evidence has any record, or there's anything in the evidence to suggest that somebody else was in possession of that property was June 27th, 2022. So based upon that, I think it's a fairly simple argument to make. The Bartlett case says, did you cease using the property for 2 years prior to our application? No, we didn't. The property was continually being used either through the end of 2021 or to June of 2022. That's less than 2 years, so it's simple math. So the long story short is by either the abandonment, intent to abandon arguments that were in the first legal memorandum or in the second memorandum under the Bartlett decision, either way, I would argue that there was no cessation, no abandonment of use, therefore that the 2460 does not apply, and we're not prohibited from continuing on in our non-conforming existing use.
John or Greg, do you have any questions regarding this first?
So, what did you say we had on record to close in 2018?
The loss of license happened in 2019.
2019.
Yes. So that was submitted in my original package of information. Just in, going back and looking at that.
Right.
I mean, that doesn't mean that they,
No, I just
you
wanted
can't just
to,
close your doors the next day. It doesn't work.
no,
that way.
I'm familiar with that place, did take a little bit to close. So,
I endeavored to try to get more specific dates. It's the best I got is people who live around it who said there was still activity going on in the property well into late 2021.
John, you have any questions?
Yeah, well, my only thing is, it's not a negative, and I don't disagree with you at all. My mother-in-law was in a similar situation somewhere else. My question, and I would actually ask this perhaps even through you to Marguerite, related to the way that you laid out the chronology, is if we know if there's any other precedent already as using basically an if but not for COVID.
Well, I think that, it's a special permit that you're dealing with, so I think that it's important for the board to make findings of facts so that you can make it clear in the record what it is, what specific circumstances in each case you're relying upon in order to move forward and grant the special permit. Here, one of the questions that was before the board from a legal perspective is this use still was the use of the nursing home still a valid pre-existing non-conforming use that they can rely upon in order to move forward with their special permit request? And, initially what was in the record before you was that the license, the loss of the license happened in 2019. Tonight, you're hearing more information about dates and circumstances that took place after 2019 that brought you within the 2-year time frame of when this developer has applied for the special permit. And I think it's important that the board not only address those particular facts, that they make finding of facts about that, so that if it's your belief that you think that there really hasn't been a cessation of use within 2 years, you make that clear through a finding of fact and you explain why. And then secondly, that you identify the COVID piece, because I do think that the COVID situation, which in the zoning world did result in an extension of other types of permits, by implication could also be used to explain sort of this extension of some of these other kind of bright line, time-based requirements that might exist in your zoning bylaw that may not make sense in the future when you don't have COVID involved.
Right.
So I think a finding of fact, if you feel it's appropriate, that the COVID circumstances also contributed to any potential delay that might have brought this outside that 2-year window by a narrow margin, is an appropriate finding of fact for you to make.
And that's what I was wondering, because if we go on that basis of that if but not for COVID, then we would be considering this differently perhaps. But because of that, to me, personally, that's the extenuating circumstance. Even notwithstanding, even if that date in 2022 was different, that June 27th date, I think you said it was. It would have even potentially been possible that residents could have been there until 22. We don't know that for sure, since there's no firm date as to when the last resident was moved. It seems to me logically that it makes sense to still potentially allow them to move forward.
So those would all be appropriate reasons and findings of facts for you to establish if you were to decide to move forward with a vote of approval tonight.
We just happen to have the building inspector here, so I'm gonna ask him, Jim, do you recall any kind of activity, in that building at that time?
Hello, everyone. I do. I would concur with Attorney Fredericks. I was actually trying to look to see when my last certificate of inspection was done, and
Yeah,
I
I was gonna
believe
ask
it
you.
expired in 2022. So that would carry the legal use of the property through the end of 2022. So I think it all makes sense. So I wouldn't have any concern about the tolling part of it.
Okay.
And I think Jonathan, your comment about COVID is applicable.
Marguerite, would you be concerned from any other perspective that this is setting any other precedent potentially, or putting us in any other jeopardy as a result of these special circumstances?
I think that, first of all, you potentially are going to be making findings of fact that say that there isn't any violation of the 2-year time frame here. For the building inspector just provided you with a third possible factual circumstance that is now in your record. So that's one piece of it. Secondly, you have COVID. And so there's not many more days that can pass before the COVID rationale is applicable to something like this. So I think that the reality is that you have a lot of uniqueness in this case that you can point to, that if someone came in the future and didn't have all of these types of circumstances and then didn't have this information, and it was pretty clear that there has not been any use of that pre-existing non-conforming use, whatever it happens to be, for a 2-year time frame, that you would be able to distinguish these circumstances pretty legitimately and with a lot of support.
Thank you.
If I may, again,
Yep.
it's this project. It's the project that every abutter came in support of, that serves the town's interest. I think all of this just suggests, and I understand her concerns. I mean, I have no problems with providing a little bit more fact, but I think that the project is so sound that it does, really meet the best interest of all involved and really should be approved.
So Marguerite, at this point, the only thing that would help you write the decision, you just need a new vote for approval, if that's the way the board felt still?
I would appreciate a vote where you actually make a vote to make certain findings of facts.
Okay.
And then you could make a vote of approval. You'd have to make another one because you've reconsidered your original vote.
So you want an actual vote where they found that?
Yep, I think
okay.
that would be
That's
helpful in this
perfect.
case
Sure.
because of the legal questions that were involved.
Yeah.
Okay,
Do you want a motion?
sure.
Here we go. Hopefully I get this right. There's a lot here. I might ask you for help. For dates.
I'll be ready.
I'm going to make a motion for the permit for 907 Center Street
Yep.
to be granted due to unusual circumstances, which are unforeseen in that.
John, not to interrupt, but we need it's 2 separate motions. So one is to make the findings of fact, and then a separate vote to
Okay.
approve.
Okay, so the first, for finding of fact, it would be that if but not for COVID,
Okay.
then we may not be able to approve this permit as it stands, but we are due to unusual circumstances. In addition, we've been presented with information that shows that the occupancy permit was still alive as of June 2022, even when the bankruptcy was finally declared, which again was delayed due to COVID.
Is there a second?
Mr. Chairman, Greg Logan, I'll second that motion.
Any discussion? All in favor?
Aye.
Aye. Okay, so now we've made the vote to approve the findings of fact. Now I just need a motion on the floor to approve the permit.
And if I
Oh,
may,
sure.
I don't know
Each
if you
one.
recall, it was a conditional approval that you had the last
Right.
time. So your conditions were
I remember it was the,
the illumination or the lighting would be direct down lighting.
Yep.
And all attempts would be made to have the dumpster company come during the day. Those were the 2 I was told.
correct. So is there a motion on the floor to approve with,
that one.
okay. Greg? I mean, John, sorry, did you say something?
Great. can do.
No, that's all right, you got it. I was listening to you talk.
Oh, thanks.
Because we're gonna, each one of us are gonna say the reason why we approve this, correct? That's okay. Go ahead.
I'm making a motion to approve the permit for 907 Center, I keep saying Main Street, Center Street,
Yeah, that's it.
with the conditions regarding the removal of any trash from the dumpster and every attempt be made to do that during the day. And I think there was one other.
Direct lighting.
Direct down lighting.
The what?
Direct down lighting.
I can't hear.
The direct down illumination.
The lighting, John, the lighting.
Oh, okay. And that the lighting be designed so that it does not peer into other properties.
Is there a second?
Mr. Chairman, Greg Logan, I'll second that.
Any discussion? All's in favor?
Aye.
Aye. Okay, so the permit passes. And if, just to make things easier for Margaret, if you could just explain your reasons why that you guys voted to approve this case based on the new findings of fact.
Mr. Chairman, Greg Logan, the reason why I'm changing my reasoning on this is that the certificate of entry that came in front of us today for June 27, 2022, and actually as the building inspector with the certificate of occupancy also reading out into the year of 2022.
John, do you have any separate reasons?
Mr. Chairman, my rationale is based on extenuating circumstances which no one could have foreseen, which was COVID-19, which closed other facilities in terms of potential transfer of patients, which closed the court system down until the court system eventually could hear cases remotely. And for those reasons, and knowing that the occupancy permit was still in existence as of June 2022.
I concur, and especially with the fact that with the last inspection being in 2022, that carries out for the full calendar year, which obviously stays within that timeline of the 2 years, so. All right, I got it all set. Thanks so much.
Thank you.
Need a motion to close public meeting?
Oh, yes, and we just need, well, sorry, we already voted to approve on it, so it's all right.
I'm going to make a motion also that we close the public hearing for 907 Center Street.
Decision.
Second that, Mr.
Any discussion? All in favor?
Aye.
Thank you. All right, so now let's go.
Yeah, he went over to see Marguerite right away.
Okay, next thing we have, we're gonna go back down to the original order of the agenda. So that will bring us to Stonegate Landing, LLC, Westerly Side of Somerset Ave, map 9, status update of phase 1. And then there has been some additional correspondence that Kerry passed on to me, which I will just read this into the record. So the first, I'll go in order of the date that we received these. The first one was from Kevin Smith Jr. This is sent on Monday, August 21st. This is went from Kerry, from Kevin Smith to Richard, and it says, "Good evening, Richard. Sorry for the delay. We are having townwide issues with our email, which just got sorted out late this afternoon. Thank you for taking the time to meet with myself and Jonathan last week to discuss the compliance issues at the playground in Stonegate Landing. The following revisions need to be made in order to meet current ADA standards, as well as the ASTM F1487, F1292 playground safety standards. 1, create a concrete or asphalt walkway with no less than 36 inches wide, with a slope less than 5% from the existing roadway to the gate entrance of the playground area. 2, raise the picnic table to establish 32 inches of lap clearance from the surfacing to the underside of the picnic table. 3, utilize playground mulch, preferably engineered wood fiber, to create an accessible surface to all aspects of the playground area. Mulch, or EWF, must be compacted to qualify as an accessible surface under current MA Architectural Access Board and federal ADA standards. I recommend a minimum of 4 inches of compacted mulch to establish a firm surface while allowing for proper drainage. 4, excavate below existing grade in the following areas and replace the specified depth of mulch to meet current critical fall height safety standards, ASTM F1292-22, and that's the 4A, large playground structure, minimum of 5 inches deep, extending 60 inches outbound of all partitions of the structure, i.e. slides, steps, bars, etc. 4B, 2 bay swing set, minimum 7 inches deep, extending 120 inches both in front of and behind the center line of the top rail. And 4C, small play structure, requires no additional depth beyond the recommended 4 inches deep of the overall surfacing. Please do not hesitate to reach out if you have any questions. Kevin Smith Jr., Dayton Parks and Recreation, Dayton Community Preservation Committee. So if you want to just address those items first, go ahead.
Yes, we had a nice meeting last Thursday around 4:15 with John and Kevin, and we talked about the fact that this playground was built in 2015 or 16, and back at that time, that might have been appropriate, okay, but years go by, and new laws come into effect, and I thoroughly agree that anything that serves the community should be accessible to everybody in the community. And even though Stonegate Landing Playground is just for residents and invited guests, if you have a guest come to your house and they're in a wheelchair, they should be able to go to the playground, okay? So John was so helpful, as was Kevin, and they pointed me in the right direction, and we kind of agreed on everything, that we need a walkway coming in, so we just have to keep it a minimum 36 inches wide, and slope it. So what I'm going to do is I'm going to, you know, on Stonegate, we have just the base down, okay, and the curving's not down. So rather than lay it in to match what's coming, so, you know, when we top it through the berm, I'm going to put the bottom of the ramp right down to the existing pavement, so there's no bump there, there's nothing. And then when we go through the pave, we can simply cut out a piece and raise it up and make an adjustment. And that seems the easiest way to do it, okay? And I was expecting a lot more expensive, you know, bouncy pads and everything else, but John and Kevin both looked at regulations and what they're offering. It is good, okay, and it will, I still haven't, I reached out for a couple of prices, but I got to put a budget together and see what it is, but it needs to be done, okay? So I'm going to undertake it and work with John and Kevin, get it done, but I also want, when that playground was approved and there was a project came in 2012 which required me to build that playground, okay, and after the sale of the 20th house or something. I don't remember the exact, but it also was clear that it was my Stonegate Landing's responsibility to build it, but it was the homeowners association's responsibility to maintain it. Now, I made the point that that's what I was told to do, and I did it. Rules change, we got to bring it up. So I'm going to undertake it and get it done. But I'm also, on my ongoing conversations with neighbors, that would definitely be a homeowner's expense. Now, I'll do it. I'll put it on my list, and we can worry about it.
Just to be clear, what would be the homeowner's expense?
What's that?
Just to be clear, what was the homeowner's expense?
Well, I built it. The modification said I build it, and then the homeowners association will maintain it. You know, cut the grass around it. Do a safety check once a year, all the equipment. Do any repairs that come up. Okay. Now, this is coming up to make it right for anyone in the area. And that came after my obligation to build it. So the playground now belongs to the homeowners association. It would be at their expense to make the improvement. Now, I know there's an ongoing concern.
When you say make the improvement, do you mean after you've paid for it to be completed?
Well, what I'm going to do is I'll do it, but then I'll bill the homeowners association.
So you'll be billing them for everything, for the building and the maintaining afterwards?
No, all we have to do is the maintaining, okay? And this is, I consider maintenance, okay, to bring it up to stuff with the current rules for handicap.
So I think the question is, for the materials that you're gonna use for this project,
Yeah.
for the labor that you're gonna use to do this, are you gonna take that cost under your hand, or are you gonna take the cost of the labor and the material, and are you gonna be billing that to the homeowners association?
All I'm gonna be billing the home association, the actual cost of the material and labor to install, nothing as far as I'm concerned, it's the hard cost.
The only question I will say for that is, and this is getting into the weeds on this where we may not want to go right now, is there's a question mark, and we've discussed this in the past, about whether or not the homeowners were paying fees or not, who controls an HOA, if there's even an HOA. So until that's clarified, who are you going to be billing?
Well, I guess
Right now, I mean.
my
if the-
biggest goal coming here was...
Let me just finish for a second. I guess what I'm asking you is, if the development's not completed, and there's a question as to whether there's actually an HOA, or whether they have or should have or will collect fees, if we go forward and say they're collecting fees from today forward, theoretically, you're still the contractor. The HOA is still under your purview. So are you paying yourself back?
No, I'm gonna hire another contractor to do the work.
But you're the one collecting fees, and have fees been established, and is there a format to collect them yet?
I'm trying to get that established, and that's one of the biggest, most important
There's no
things to
fees
do.
established. I'm sorry to interrupt. There's no fees established. We've never paid any homeowners association dues.
So I guess we can't take any public input yet, I don't think.
No.
But, so, that's okay. No, that's okay. You didn't know. Don't worry about it. I guess all I'm trying to establish is that when you made the comment about you're going to bill,
Right.
who are you going, there's nobody to bill except
No
you
HOA to build
right
yet, is
now.
what he's saying.
Yes, that's exactly what I'm saying.
Well, maybe that really is the person we should talk about, and I want to talk about it a lot tonight, if I can. Okay?
We can. Let's just go. We have one other correspondence that I wanted to get to.
Okay.
I think this is what you you sent, Carrie. So this was this morning. You sent this to Carrie. Just want to read it into the record. Good morning, Carrie. I would like to address in an email sent to you July 10th, 2023, copy attached from Julie Heber of 953 Stonegate Landing. That was part of the meeting packet for the July 25th meeting. Included in the email is a copy of the document entitled, quote, Stonegate Landing Homeowners Association Acknowledgement, end quote. The document, this document ends with, quote, the first association fee will not be set or due until the subdivision is completed, end quote. Julie first brought this document to my attention at a meeting of the homeowners held February 26, 2019 at the West Congregational Church in Taunton. That meeting was attended by 22 of the then 28 homeowners. She told me that she had the document but not with her. I asked her to provide me a copy. That copy was never provided until she attached a copy to her email to you. Julie and Nicole purchased the property February 16th, 2011. At the meeting, I dug into my files and found a copy. Julie's indicate emails that, quote, many of us brought our copies to the meeting, end quote. However, in digging, I have not found any others. The document provided was simply a sales concession. At the fourth sale since the beginning of my involvement in Stonegate, the economy was still recovering from the Great Recession, and I needed a sale. At the time, and still today, the condo fee was $20 a month. Effectively, Stonegate Landing LLC was agreeing to pay the HOA fee for that property, and that property only. It was not transferable. Optimistically, I believe that I could complete the project in 2 to 3 years. Of course, that didn't happen. As regards document, I would offer the following. 1, it is only binding to the parties who signed it. 2, it was not for the benefit of any prior or future Stonegate homeowners. 3, it is not dated. 4, there is no consideration. 5, there is no end date. 6, it is not a recordable instrument. The document was signed more than 12 years ago. Whether it is or ever legally enforceable, I don't know. Julie's email indicated that, quote, many of us brought our copies to the community meeting at the community church, end quote. I doubt any similar documents exist, but if there are others out there, those homeowners should provide me a copy. And that is sent from you this morning to Carrie.
Mr. Chairman, can I ask, is Veronica on with us tonight?
I didn't see her
She's
pop
not.
up yet.
Invited, but I don't see her there.
Okay.
The reason I'm bringing this up, Mr. Chairman, is because I know that Veronica Truel had indicated that this particular issue with regard to the past fees is something that she needed to discuss. And Marguerite, I don't know if you've spoken to her or not, but at this point yet, but it was something that she needed to discuss with her legal counsel
Okay,
with regard to DCHD.
okay.
And HUD as well, to see how they wanted to proceed on this part of it, because this is part of the 40B requirement and process.
Yep.
So I don't know that we can even address this at this point until we get more information from Ms. Truel with regard to where they stand.
Okay, Greg, do you have any questions or anything regarding his email or anything else?
Yeah, so,
Mr.
I
Chair.
mean, that was brought into the record last meeting. I saw it, I witnessed it myself. It was on the purchase and sales agreement for the property, stating what we read it into the meeting. So that's what threw me a red flag. And I'm reading this further and further, and there's a lot of red flags in this homeowners association that contradict each other. So I'm not opposed to waiting for her to attend the meeting so that we could get some information from her, but I do have some concerns with the homeowners association. Who's established, who has paid, who has liens, who does not. I mean, it's this whole homeowners association on one line item states he's capable of doing. The next line item, 2 line items down, states that he's not to do it until a certain date. So there's a lot of things in this homeowners association that needs to be hashed out, and if she can help us out, I'm willing to wait for that. I know there's probably other members on the board that want to speak on this, as well as Marguerite, so.
I believe also at the last meeting, and I will just segue for a second, just to simply say, when we met with Mr. Fedorov last week to at least go over the playground, it was very civil, very cordial. He seemed very willing to do what it's going to take to bring the playground up to par and get it open so that, you know, the residents can use the playground as quickly as possible. I just want to state that for the record. The other thing that I would say, though, is that when we had the last meeting, you were asked by Mr. Logan to come to this meeting and bring ledgers showing any payments that have received or billings that were made to residents. And I'm wondering, and you said you would provide that information to us?
Yeah, Greg, so what was it
Yeah,
exactly?
so I was asking you to bring in the ledgers and showing me that you've been doing all your meetings, acting as the secretary, you're holding all positions, but you're supposed to have records of where you've been spending the money as you've been collecting.
Honestly, Mr. Logan, I missed that.
Okay. Yeah.
I would have done it, you know, I put, for that meeting in 2019, I submitted, the expenses for the previous year and the proposed budget for the next year, and,
Because it states in here, you're supposed to
Yeah,
file every September, third week of the year in September, and file for the homeowners association, and have you done any of that since you've been collecting any of this monies?
The biggest issue for me is with the homeowners association is total lack of any communication.
Sure.
Okay? It's just something simple, like I asked everyone to give me their email address, so that in 2019, when I set up that meeting, I had no email addresses. So I had to write 28 letters, put them in an envelope, send them certified mail, return receipt to announce the meeting. And then we had bad weather the first week in February, so I had to let them know I was going to continue to the 26th. And because I don't have anyone's email address, I went door to door and left them at the doors, okay? Now, that's not how you run a homeowners association. Every association is online, okay? I should be able to communicate directly with every homeowner in the neighborhood. Nobody will cooperate. I do have addresses of a number of the homeowners. And even after the last meeting in July, I met 4 or 5 homeowners. I think Andrew Sheedy was there.
If I can interrupt and ask a question, which is going to what Mr. Logan, I think, was basically looking for example. Could you show us, would you be able to show us that annually or biannually you sent bills out to all of the residents?
It's some work for me, but I can have it, sure.
I mean, those, I think, are things that we'd like to see, that you've actually billed them regularly. that you've reached out to them one way or another regularly, even if it's by snail mail, so that we have something to work with at least. Again, I think that, I'm going to go back to what I said a couple minutes ago, Mr. Chairman, which is I think whether or not he should have or shouldn't have is, in the past, is not something that we might not even want to get into at this point or touch, because that's something we need
I
to.
want to read something. This is Article 53 of your comprehensive permit that you had put inside. The applicant is responsible for maintaining of the stormwater management system, utilities in the road, trash removal, and arrangement concerning school bus pickup and drop-off until the earliest of such time as the town has accepted the roads, or by 2 years after the completion of the project, the date of completion to be determined by the building inspector. The homeowners association assumes all responsibility.
It's right there, sir, okay? And on the bottom of the page, there's something quick about the
It
one.
contradicts itself next line's
But
down.
what I want to do is that agreement was signed in 2004.
Right.
My predecessor didn't, what about built the road? And early 2006, he wanted to get his first house up. And so the ZBA required that he put together a homeowners association.
Sure.
So that was done in 2006. Now, in the homeowners association, and you probably, I don't know if you had a copy with you.
Yeah, I do. What article?
It says, subject to accordance with the agreement, the duty of the association shall include own, maintain, manage the common land and the roads until such time as accepted by the town of Dayton as a public way. That came later. Still part of the record. So you're right, there's a,
So what I'm trying to say is the comprehensive permit, when you came in for relief of conditions, when you took it on from a 55 NOLA to make it 2 bedrooms,
Right.
the article was nothing in any of our paperwork on the zoning bylaw was any kind of relief of change of the comprehensive permit of your homeowners association. None of it was.
nothing was.
Yeah, so this is why I believe that we really need to have the lady that works with the HOA and all that stuff that can help us out, get all the proper paperwork together. Meanwhile, you're gonna get me some paperwork on what you paid for snow plowing. That's monies you spent.
I've got
Things
it.
are, I mean, I get it, you know, but we need to see where you're sending the money, because on here, it says annually, you're supposed to do your report, the second September of every year. This project's been going on, were you in school?
Yep.
So it's been a long time.
We go back to the beginning. of time.
Yes, and those are some of the concerns I have, you know.
On that point, sir, I want you to know that I have been in touch with Veronica Trullo as early as Friday.
Okay.
All right? And she has agreed to work with me.
Sure.
Okay? And from the 40B perspective, fix what's broken. So what I really want to do is have a meeting with Veronica there and all the members, okay? But I don't want to spend $1,000 in certified mail if people could just provide me the email. That's all I, we have to start. I am not in any way, when we had the meeting in 2006, there was real pushback, 2019. And I stood in front of everyone, listen, we got to just work this out, okay? It isn't my way or the highway. We have to talk about it, okay? And get something done. And then at that meeting, we voted in a committee to meet with me. It's difficult to talk to 28 people at once. And there were 5 or 6 people on that committee. And Andrea, who is luckily is here now, okay, we had a follow-up meeting at her house, and then it just fell apart.
Marguerite, were there ever any changes made to the comprehensive permit once Mr. Fedorov took ownership, as far as you know, with regard to?
Absolutely. It was like the usage for the age group. We released the air conditioners from the front windows. We did, it was like 3 or 4 things, but not one of these.
Right, that was what I was going to ask, that anything that we don't know of necessarily that you found that talks specifically about an HOA or who's responsible for what?
Yeah, there were changes. So, condition 47 was the original permit condition that talked about the homeowners association's responsibilities as a whole. There were other references to the homeowners association in it. Condition 47 was further modified in 2009. I don't remember when you took over, but this was when there was the whole modification, there was a new modified plan created, and that's when the bus stop turnaround, so parcel 6 was established, parcel 5 was established, on which includes the sewer pump station and the playground as well. However, this homeowners association document that I have in front of me, and I obviously haven't researched it further, but I don't know if that was ever updated. I mean, that only references the original plan that had 4 common areas of land, so perhaps that hasn't been updated. If that's the case, then I think it's certainly an open question as to whether or not there's any obligation on the part of the homeowners association for, yet, at least on record, for the playground area. There's a comprehensive permit condition that says that the homeowners association needs to be responsible for that.
But not until after the project is complete, correct? Not beforehand.
No, it's not necessarily limited to being until after the project's completed. And, I mean, my initial glance at this, it appears that it's basically, you get sold the lot, you have a percentage interest in this homeowners association. We've seen homeowners associations in other projects where they really don't transfer from the developer to the homeowners until a certain amount of
Right.
lots have been sold, but that doesn't appear to be how this one's worded. But, you know, the zoning board's concern around the homeowners association really needs to be with regard to whether it's compliant with your zoning comprehensive permit decision. If there's a dispute between people who are members of the homeowners association against other members of the homeowners association, that's a private dispute. There's other legal remedies that they would need to pursue, not before you. So I appreciate, as citizens of this town, that you are taking an interest in some of the answers to some of these questions. I'm not sure Mr. Fedorov legally has the ability to do what he's saying right now he's intending to do, but I'm not sure that's something that you really have any jurisdiction over. You just need to know that the homeowners association is required to maintain the playground recreation area on parcel 5. So they have an obligation to maintain that.
Even now?
Well, it's interesting, I mean, the problem is that it wasn't amended. When your zoning amendment happened, your zoning decision amendment occurred, they didn't also then amend the homeowners association to reflect that. So the association agreement doesn't actually reflect what your comprehensive permit
Right.
condition now requires. So you could insist upon an amendment occurring, but, you know, whether or not he has the ability to retroactively charge, I don't know. This gets into areas beyond the zoning board's purview.
So I guess at this point, any grievances that the residents have, they need to be taken up with him or legally.
Or potentially through DHCD.
Right,
and
right.
God, it sounds like they are willing to get involved in this because they have an interest in a different way.
So it sounds like to me going forward, that's what we need to do. We need to have
Absolutely.
them be in touch with Veronica, is that her name, sorry?
Veronica Truel, yes.
Yeah.
Yeah.
And I think at some point in time, you're going to want an amendment to this homeowners association agreement.
Should we make that once maybe we've heard from Veronica?
I think it would be helpful because I assume that there may be some provisions in that amendment that you're comfortable with or not,
Okay.
once you have a better input from.
Okay, so Carrie, do you think maybe we could send out, I know you did send a correspondence about tonight, she's not here, but can we maybe send out another piece of correspondence to her, just reflecting all of this? Letting them know that at this point, unless it's related to the comprehensive permit and the zoning bylaws, at this point, the zoning board doesn't really feel that they should be getting involved with any kind of, I'm not saying the matters aren't relevant or not important, they are, but just not under the jurisdiction of the zoning board. So if she can maybe perhaps gather that information from the residents and then at that time, if and when an amendment is needed to the comprehensive permit, we can then talk about that, but I don't think we need to be discussing anything like that until we do hear whatever she finds from them. All right, so I think that we're all set for Stonegate Landing for tonight, unless any residents have anything.
Something on the streets?
I don't know, did you want to have a, I mean, I think that you're hearing him at least say that he's going to be taking action on the playground, right?
Yes.
He wants to do,
Yes.
yes.
Mr. Chairman, just to wrap up, I just want to get it settled, okay? I want to be fair to everybody, okay? You're hearing from a certain group in the neighborhood, and their attitude is, there is no association, there are no fees due, okay? Fedorov is going bankrupt. He's trying to squeeze us for money. Isn't it ironic that a year later I was out of bankruptcy and I've been down there cleaning the roads and fixing things this whole time? So it's like, I don't know, try to explain how I feel. It's like, hell no, we won't pay. Just shut me down. What's the old expression? If everybody's right, everybody's wrong.
And I think we'll hear more about this when Veronica has
think
talked to
she-
the,
yeah.
to the residents.
Yeah, I just want to get them in a room
We'll-
and
we'll-
resolve it. Get them,
think
I
she'll
mean,
help you with that.
She
you've
will.
had a homeowner complain after 11 years in a house, she's getting water.
Okay, I mean,
All she had to do is call me.
I understand that, but I think
Okay.
the last thing that what Marguerite wants to see is that what's the playground. So you were going to be taking care of that?
Excuse me, sir?
You're going to be taking care of the playground, correct?
Yeah, now, he's telling me, the thing it is, maybe if I got all the homeowners together.
Are you taking care of the playground? Yes or no is the
I will,
question.
yeah.
Is there a timeline on that we can look to?
Well, I'm gonna get prices and get it going, okay? I don't know how available that wood fiber is and different things, if it's readily available. I have to make a few phone calls and,
So,
but if it's
is
out
there a
there, I'll get it.
timeline we can get? Do you have any idea? Are we talking a month? Are we talking 2 weeks?
Well, I'll tell you is that I'll be back here at the September 25th meeting, and I'll tell you every effort I made to get it done. If I was able to get it done, it'll be done.
Can you provide us with, at least with dates at that point?
What's that?
Can you provide us with, I know for some of this material, it may take time, but can you provide us with dates on that meeting?
That's what I'm saying. We just met on Thursday.
Correct, so
And I
so
know
we
we're
know
gonna
you haven't
talk
gotten
about
to
it
that yet.
tonight.
All we're asking is when you come back in September, can you provide us with dates? It'll be done by the end of October, the end of November.
As
Can you
soon as
commit to that?
I know where the material is, how soon I can get it. I get local people to install it, but I have to get the material. I wouldn't know where to go right now. to
Okay.
buy it, Okay? I can't commit until I find out what
If you don't know where to find the material, reach out to me. as the
I'll do it
ADA
tomorrow.
coordinator.
Margaret, is there anything else that you want us to suggest with this right now, or no?
We have an engineering
You
report for
asked
the
him, at this stage, there's nothing pending before the zoning board. You've asked him to come before you to provide updates on certain activities. I don't know what you talked about last month, so did you talk about the scope of work?
Not in detail, no.
No. Did we get an engineering report, Zach?
No, not yet. That's part of why
Not
we're,
yet. We have, so the peer review is coming up with the quoted amount to give to you, so we can come up with a contract.
Right. I didn't get that.
Nope, that's all.
What was it? I'm sorry?
So the peer review is comprising the contract with the quoted amount, so that we can have that signed, and then have that, and then the report issued. Yep.
all right, so if that's all the board has for tonight. We can go on, well, regarding that item agenda, we can move on to the next. Was there anybody in the butters that were here for this case tonight? Or just here for information? Or not butters, sorry, residents. Okay,
There was
so
some,
go
Can I
down.
make one more comment, Mr. Chairman?
there might have been some.
I've been here every meeting for 6 months, ready to answer every question. Tonight, we have 2 homeowners. They should be here.
I'm online too. I'm a third homeowner, thank you.
But just because they're here doesn't mean they have to speak. If they have nothing to speak about, that's fine. They're just here for information, just to
Well,
listen.
at least we could talk, that's all.
Okay.
Did the gentleman online want to say something earlier?
Sir, the one that's online, Tom, okay, if that's you, did you have anything specific to say, or are you just here to listen?
No, I was just, listening to what you guys were saying.
Okay.
I live at 951 Stonegate Landing. I mean, just regarding some of the comments that, you know, we've heard, I've only received that one bill back in 2018 that Richard had sent out, along with every other neighbor, so there has not been, you know, routine bills that we've all received. And I mean, I think, you know, Mr. Fedorov's lack of organization speaks for itself. You know, you guys asked him to bring stuff to this meeting. Last meeting, he didn't bring it again. It's just kind of the same old story. So I don't like hearing him kind of mention that, you know, there's groups of neighbors that are against him. I mean, it speaks for itself. I think everything that we're all kind of witnessing unfold. I mean, there has never been an established routine meetings of the HOA since I lived here since 2016. So just wanted to, you know, clarify that.
Okay. All right. Thank you. All right. So we're going to move on now to the Bruce LLC.
Thank you,
Thank you.
gentlemen.
Bruce Development Corp., Arborcrest Estates, Fremont Street, map 4, lots 54A, 55, and 377. Status update of project. And just announce your name for the record for us whenever you are ready.
State owns.
No, this is Bruce
Oh,
LLC.
this is the Bruce. Yeah.
I didn't see you there.
Good evening. My name is Joshua Glass here on behalf of the applicant. I'm here this evening with Outback Engineering, LEC Environmental, who's here via Zoom. That's Brian Madden and Chris Agostino. This evening, I'd like to provide you a brief summary of the project, share with you some recent developments, sort of summarize in more detail the letter that you likely have in the packet before you. I think it would be helpful, I'll start with a higher level summary. This project, Arborcrest Estates, is a 40B located along Tremont Street. It's 84 lots, 26 of which are affordable. 21 of the lots are along School Street. 7 are Form A lots along Tremont Street, and 56 lots are in the main development area. It's approximately 113 acres with approximately 75% open space, and it's broken up under the permit from a unit development perspective into 3.5 or 4 phases. So, with respect to the primary reason we're here this evening, we had planned to start actual construction of a wetland crossing or construction access in the vicinity immediately off of Tremont Street, extending approximately 450 feet and clearing 4 lots. We had sent that notice to the town and this board on August 1st. We were approached by the zoning enforcement officer with a request that we maybe take a step back, have some discussions with the staff, as well as and make a presentation to this board to provide an update, share a little more detail. So in the spirit of cooperation, we wanted to do that. We're here this evening to accomplish that. Since that time, or as part of that initial conversation, we had a pre-construction meeting. We've had a site walk with the zoning officer, our engineer, and an abutter. I won't speak for the zoning officer. I'll let him speak this evening if he so chooses. But I will say that I believe we've addressed most of the concerns that arose. Again, we're here talking about the construction access and the wetland access. We're not talking about the overall. Tonight, what we'd like to do is, again, provide a summary, answer any questions you might have, and put our contractors back in the position to remobilize. They were prepared to mobilize and begin on the 14th. They agreed to stand down for a few weeks in the spirit of what we're trying to accomplish here. Obviously an expensive proposition, but they understood. I want to be clear for yourselves and for the members of the public, we are not seeking a building permit right now. We realize that there are a number of steps that we need to accomplish before we can seek a building permit, including coming back to you with a definitive compiled plan set that addresses open items such as utilities, as well as a number of conditions that remain in the permit itself. So with your indulgence, and not to bore folks, but I want to provide a brief history. This was originally approved in 2003. It includes 92 conditions. We will need to come back to this board to discuss some of those conditions, but we think, and we're comfortable that right now we can proceed with this piece. We think it's actually a very responsible and appropriate way to commence this component of the project, which I'll get into. Since it was approved, there were 6 or 7 appeals by an abutter, numerous trips to the HAC in the appeals court, attempted appeals to the Supreme Judicial Court by the abutter. The litigation finally ended in August of 2020. We filed an extension request with this board. It was granted, which we appreciate. And since that time, since it was approved in November of 2020, we have expended an enormous amount of time and resources on engineering. We have working towards assembling the compiled definitive plan set that we will ultimately need to provide this board. That a draft of that, in case you see it floating around town, exists, but only in so much as we have provided it to the North Dayton Fire District and the Sewer Commission. The document is essentially compiled of a lotting sheet and the approved notice of intent plan, which you have in front of you. The idea being that we can work with sewer and water to confirm easement locations and details that we're required to put in front of you on the final definitive plan set. That plan set has not been submitted to this board yet, but the final version will be. So in terms of the permitting process and the steps that we've taken and where we stand on that side of things right now, Rockland Trust has provided extensions of the New England Fund, or the Federal Home Loan Bank of Boston has provided extensions of the New England Fund. That approval is currently in place. The MEPA was reviewed and issued, no environmental impact report required. The next 2 pieces are a little more substantive and probably the ones you are going to care the most about for purposes of this piece of the project. The first is the superseding order of conditions issued by the DEP, which I'm going to ask Jason Youngquist of Outback Engineering to sort of help me with and help make a brief presentation. And then the second piece is the existing the natural heritage approval, which Brian Madden from LEC Environmental can help provide some additional detail on. But as a non-engineer, I'll attempt to give you a brief summary and let them each speak. Well, I don't know if Brian will need to speak, but I'll let Jason speak and Brian if necessary. So this wetland crossing was approved by DEP via superseding order, and that order has been extended through January 24, 2026. So we have an approved and recorded superseding order, as well as an approved notice of intent plan, copies of which were provided to you as part of that August 1st correspondence. This wetland crossing and clearing will be conducted in accordance with the detail that you see on that plan set. That superseding order has numerous conditions that we've complied with and or will comply with. For example, construction flagging in the vicinity of the project. One question that was raised that we want to make sure we address this evening was what differences exist within the approved 2003 plan from the zoning board, the preliminary plan that was approved as part of the original 40B permit, and the notice of intent superseding order plan that you have in front of you. And the non-engineering summary is that the 2003 plan was the preliminary plan, and this it was then taken and engineered and the detail provided, and that's what you have in front of you. There's no substantive change. It's same number of lots, same general location of roads. It was shown as a concept in 2003, and now it's been engineered. It's been peer reviewed. In the area of the wetland crossing, it's effectively the same. I think like 2 or 3 flags got moved. We realize if lots start getting moved around, infrastructure gets moved around, that we would recognize as something substantive the ZBA would need to be aware of and would be something that would obviously come back to you and discuss. So I'll hit pause on my part of the presentation to give Jason Youngquist an opportunity from the engineer's perspective to address a little bit of the changes between the 03 plan and the notice of intent plan that you see on the screen and on the board.
How you doing? Jason Youngquist from Outback Engineering. We were brought onto this project to be the primary engineer as it moved forward now that it had finally been approved. So originally in 2003, the comprehensive permit plan, which was preliminary in nature, laying out the lots, how many lots they're going to be, the roadways, where everything's going to sit, was approved by the ZBA, as Josh had mentioned. And then the notice of intent plan was created to provide a great deal more detail on the wetland crossing, the drainage design, how it complies with stormwater management policy. And so it's the exact same layout, same number of lots, roadways are in the same place. but it goes into a lot more detail. Where the 2003 plan just showed a couple circles where the drainage was going, this goes into the actual design of the drainage systems themselves, all the components, so it can comply with, pre-treatment, and how it can comply with the best management practices for stormwater management policy. So it's the same plan, same layout, just more detail. And that's what was approved with the superseding order of conditions by DEP. And that's what they're going to be constructing when they go forward. The initial phase right now is just the first 400 feet of the roadway, the wetland crossing. There's a culvert that goes there. And this will be utilized as the construction access for anything permitting process. If we have to go out and dig, any holes for, test holes for anything for permitting. Now we have a place where we can get machinery in there. We can park the trucks, offload machinery, and we'll have, the roadway to at least a subgrade established. So we don't have to park on the road or any hazardous conditions like that. So I like to kind of consider this, even though it's building the road to subgrade, it's essentially, it's construction. It's a construction area where it's going to be established. Make sure there's no runoff or anything going to Tremont Street or affecting the wetlands in any way. We've also filed a NIPDES permit with the EPA, and we have a stormwater pollution prevention plan that is in place. So when they do start doing their work, we can make sure if there's any storms, anything like that, it won't impact the wetlands in any way. So that's about it. I'm happy to ask Jason and Brian to stick around for any questions that may follow at the conclusion of the presentation. So the next permit that I want to talk about, which is Brian Madden from LEC Environmental, who's with us by Zoom. I don't know that he'll be needed, but if I say something wrong, I'm sure he'll correct me. So the animal in question here is the eastern box turtle. It's an animal of special concern. Natural Heritage approved this project, but they broke it into what I will call Heritage Phase 1 and Heritage Phase 2. Those phases, because I don't want it to be confusing, do not align with the phases in the 40B permit from a construction of houses point of view. Natural Heritage looked at it and said, Phase 1, which is this initial project that we're talking about, results in a no-take, and they laid out some conditions which we have complied with and will continue complying with when and as appropriate. So, for example, one of the conditions was we had to put up turtle fencing, perform a turtle sweep. Those have both taken place. We will have to follow the Eastern Box Turtle Protection Plan, which is not a plan sheet, a plan set. It's actually like a set of guidelines to be followed by contractors for the safety of the turtles. And then at the conclusion of this project, we will need to submit a report to Natural Heritage, which will happen when it's appropriate. Heritage Phase 2, again, terminology I'm using just so there's no confusion as to the phasing of the 40B itself, is really essentially the rest of the project. And that we have some preliminary concepts with Natural Heritage as to how we are going to pursue that. It will require initially a conversation with the Conservation Commission. Lisa's hearing that for the first time right now because it's not something that's gotten to the point of putting in front of them and using their time quite yet. That may or may not be an avenue, but we have worked on that with Natural Heritage so they understand that we need to come back for the balance of the project development. And then we realize, obviously, whatever the final plan is established with Heritage will need to be incorporated into a definitive plan set that's put in front of this zoning board. Brian, I want to give you a chance to chime in if I missed anything. All right. Chime in later if you need to.
No, sounds good, Josh. Thanks.
Okay. All right. The NIPDES was issued. As Jason mentioned, the project will have SWIP monitoring and reporting. We have met with the North Dayton Fire District a number of times on this project, or once or twice on this project, and have submitted the application to them. The water and sewer component of this, I'll start with just the water. It's a little bit funky. If you read the condition, it almost implies that there's some element of Taunton involvement providing water, but this system is in the jurisdiction of the North Dayton Fire District. And so we had to discuss with them, you know, water pressure, the role of Taunton to the extent there is one, which there might be, and have submitted to them now an application and plan set that reflects the design that we think works, that will likely need to be taken fairly far with North Dayton Fire District, and then in some capacity Taunton because of the intermunicipal agreement that they have for the purchase of water. On the sewer side, we've met and discussed this project with them a number of times as well. We've actually met with their peer review engineer, Russ Kleeklamp of GHD. Again, a little funky, similar condition, talks about Taunton providing sewer connection service. I think as a practical matter, again, this is in the jurisdiction of the Sewer Commission. So we have put the application in with them for their review. You know, this project, it's one of the reasons why we need to put the access point in. It's got a pump station. When we've done other projects with this particular peer review engineer, he's asked us to go in and do some test pits to confirm no ledge in certain areas, dewatering won't be required, so that we're comfortable that these sewer pipes, depending on their depth, are going to be accessible and easy to construct, install, and maintain. So those two applications have gone in. Shifting gears to the sort of hard side of the project, the construction, pre-construction component since the extension. We've been in process on this particular piece for a little while, this access point. In fall of 2020, the fencing went in and the turtle sweep occurred. We've bid out the project and awarded the project. We signed a construction agreement with SLT Construction Corporation. The shop drawing and engineering drawings have been reviewed and approved, and the culvert has been fabricated. That took some time, designed and fabricated, and is ready for installation. We've had the pre-construction meeting. They were mobilized and prepared to commence on prepared to mobilize and commence on August 14th, but have agreed to hit pause. And that effectively, with a lot of words coming out relatively quickly that hopefully was helpful and not too confusing, is a summary of where we are and hopefully gives you a fair glimpse of the project today. And so sitting here today, the primary reason we're here is we do want to have a good working relationship with this board. We think it's going to be absolutely necessary to get to the sort of building permit side of this, the shovel in the ground for houses component of it. Again, won't speak for Mr. Aguirre, but I hope that our conduct with him has demonstrated our intentions to conduct ourselves in that fashion. Right now, we're really asking you, or not asking, but we're here to talk about the 450 feet of roadway we want to put in, clearing of 4 lots, culvert installation for the wetland crossing. Again, doing it under peer-reviewed and approved DEP plans. We, again, realize we're going to need to come back on the bigger project with the fully compiled definitive plan set. And we'll probably need to work together with this board on some of the conditions and mass housing on some of the nuts and bolts of the 40B itself. But for now, we're looking for a responsible and safe way to access the property. Jason talked about some of the reasons why. We cannot come, by the way, into this project from what's known as Chase Street Extension, the access point to the north off of Chase Road. We can't use it for construction access, so this is our own. So this access off of Tremont Street is our only permitted access for construction. Since you've received the letter that's probably in front of you this evening, like I said, we've had a pre-construction meeting. We've walked the site with the zoning officer. We've met with the abutter, Mr. Arroyo, numerous times. I won't speak for them, but we have addressed 2 concerns that were raised. One is installation of a gate along the entryway upon completion of this access point. And with the abutter, some vegetative buffer to provide some level of visual and probably eventually sound protection. The details of those haven't been finalized and established, but we've worked with them and agreed that those are things that we can include as part of this to address the concerns that were raised. Again, I just want to point out we are not seeking a building permit right now. We know we'll need to come back for that. The final plan that will be put in front of you will be impacted, by the utility design and peer review, the input of mass housing, and very candidly, the sort of 92 conditions that exist in this permit that are going to need to have some tweaking, I think, sounds like you guys have dealt with that at least once already on other projects. So unless Jason or Brian has anything else to add, or Chris, I think that's sort of where we are today, and happy to answer any questions you might have.
I'm just probably gonna turn it over to Jim first. Jim, not that you have any questions, but maybe you do. But first, I guess your side of everything, and just to see what.
Yeah, no, hello, board. Hello, everyone. No, actually, I concur completely with Attorney Glass. And I want to thank him and his colleagues for the cooperation that they've shown when I initially started the discussion about when the actual construction date would be. I think everyone's eager, especially a developer, to get this started. This has been a long time coming. However, I think this presentation was necessary to bring everybody up to speed, especially since this was approved 20 years ago. Understanding now, especially after the pre-construction meeting and the site visit, about what they're actually after, it makes perfect sense from a construction standpoint.
Okay.
Right now, there is no access, no safe access to the property from Tremont Street. Just the day we were there, the cars whizzed by. It's certainly something that would put people in danger. So to put 400 feet of road in is appropriate.
Okay.
And because this project has a lot of unanswered questions, such as water table elevations throughout, et cetera, because as my knowledge, the property hasn't been accessed in earnest for that, correct?
We haven't done, I think each lot is required, or
Right.
each grouping of lots is required, as Jason said, and that has not happened yet because we can't get a rig in
Right.
there.
So we're a long way off from building permits, and all of that site work needs to be obtained prior to getting to that point. So I feel that what's before you is an appropriate first step in getting this project moving. I can't answer the questions about whether or not all of the conditions have been met to date. I take Attorney Glass for his word, however, we need to vet that.
Yeah.
And that being said, everyone at home needs to know that once this roadway is built, which would be, as said, in a subgrade, it wouldn't be a finished road. The town has looked after to make sure it is secure.
Okay.
We don't want people to be riding through, even if it's just 400 feet of roadway. We don't want prying eyes to be on the property, potentially getting hurt, et cetera, because it will be some time before we actually get to a permittable project, meaning a building permit.
Right.
But I don't have any problems with this moving on as discussed, and I'm actually looking forward to working with them. And I want to commend you for starting this off on the right foot, so thank you.
Cool. Do any board members have any questions? I mean, we need 3 board members for this, correct?
Yes.
Yeah, at this stage, I mean, doesn't have to be the same 3.
It can't be, because I was 10 years old when this happened before us, so none of us were here. I don't think Greg was even here yet, right?
Mark,
No, this was already
I
started.
think my dad, when he was the only one that
Yeah.
was. Oh.
I remember them. I was, and I remember you as well.
So-
But I was going to say the same 3 going forward.
Oh, okay.
You can make it the 3 tonight.
Yeah, I can,
And then you can make
potentially.
another 3 for a different request that might be before you.
Okay.
Yeah.
So-
Do any board members have any conflicts?
I do.
Okay. What's yours? Just out of
I
curiosity.
own land right next to it.
You own land. Oh, so you're a direct abutter.
Yeah.
All right, Greg. Do you have any conflicts? I'm sorry, John.
I do not.
Do not. Either of you guys? Nope. Okay, so Greg, if you can assign, John,
Sure.
assign 3 voting members
Let
to
me,
this.
before I assign Marguerite, let me ask if for the 3 that I assign, as we go forward in this process and eventually have to look at other aspects, will the same 3 individuals need to be the ones from day 1 through day end?
Oh,
For other parts of the project?
That's what I was saying, and you probably missed it. It doesn't have to be the same 3 going forward. It should be the same 3 for purposes of this request that's before you tonight, which is to approve the construction. The proposal is to construct, as I understand it, about 400 feet of roadway. But then down the road, if they come before you, let's say for a modification of their comprehensive permit, you would have to sign a new group of 3.
Okay.
Okay, so that's what I wanted to do. When we get into the other permitting, that theoretically. could-
Okay.
Okay.
So who are the 3?
So, I will exclude myself and the 3 of you,
Right.
excluding Greg.
That's myself, Dave, and Elise.
Correct.
Are the 3.
Can I have just one moment with Attorney Agostino to ask him a question on procedure on our end?
Yes. Yep. Yep.
Thank you.
Yep. You're all set.
I believe so. I just, in all candor, I'm not sure that you formally have a request in front of you, but if you are prepared to support and approve this, we're happy. That would be a great way to kick this off. And the reason why I say that is because
I probably spoke a little quickly in that, but I think you need 3 voting members because it's a group of 5, but it's a zoning board of 3, so in case motions need to be made, we need to
Sure.
identify.
I guess, sorry, my point of procedure, candidly, my point of procedural question was, I don't know that we know that we necessarily need approval of the zoning board, but there's almost no way of saying that where it doesn't sound anything other than appreciative. So if the zoning board is comfortable, we would of course appreciate
This was more
that.
for a status update, but I knew that if anything were to come up that we would need a vote on, we would need 3 voting members. I didn't want to get too far into the discussion without having those voting members in place, that's all.
No, and I appreciate that. Thank you.
Any board members have any questions?
I'm just curious, do we have any, is Conservation Commission, I know you've gone, in the weeds and other things over the years, but do we have anything recently from Conservation Commission?
So the Concom doesn't play an active role in this project. They have a limited role under the superseding order.
Okay.
It's actually drafted into the recorded order, but at this point, this project's under the jurisdiction of, frankly, this board and the DEP.
Yeah, okay.
Is this, it's probably way out of the realm here, but we're running into a situation where developer doesn't have the funding to finish a project of this large. How does this being bonded with the
We're
town?
gonna pay for this. We're gonna pay for this project right now. It doesn't need to be bonded. We'll complete this part of the project. The project itself
Yeah.
the overall project has a number of documents that Attorney Mitchell will need to review related to the 40B components, construction and performance guarantees, but this one's going to be, and that, because it relates to when you can release lots and installation of infrastructure, but we're not selling any lots right now. We're not pulling a building permit.
No, I understand that, but I'm going future down the roads. Like I said, it might have nothing to do with this, but we're running into a situation, or if we shall run into a situation that you ain't able to complete the project, it's not fair to the people that live in there to have an unfinished road. So we sometimes hold house lots, or we ask you to get a performance bond. I don't know what was written in this. This was way before I was involved.
This, I won't speak for Attorney Mitchell, but this, as currently drafted, contemplates, I believe, either covenant and/or performance bond, effectively indicating that the infrastructure has to be complete, I think up to something maybe like not quite the finished coat, but the rough coat. I'm using the wrong terminology here, before you can release a lot.
Before I go over to the members of the public, are there any people here from town boards that want to speak? Jim, do you have anything else? No? Okay, are there any butters or members of the public that want to speak? We just ask that you speak with your name and address for the record. Whoever wants to go first, doesn't matter to me.
Name's Robert Savell. I'm Ruth Sarah's husband. Ruth Sarah owns 707 Green Acres. She inherited from her father, Robert. And I just wanted to verify for everybody that we've taken over the place, and we plan to protect the access. So I believe Outback Engineering crossed our property to do some of the surveying for the wetlands, and that would be trespass. I appreciate it if you can continue with that.
What was your address for the record? What?
707 Green Acres. It's the Chase Street extension,
Oh, okay.
which was a paper road, which was just a perspective road, which had never been okayed.
If you want to speak.
Through our property, so.
Okay.
The result of the court cases was that the Superior Court was not going to tell the zoning board what to do, but they said they saw no reason why, if any construction proceeded or attempted to proceed on a property, that we wouldn't be able to enjoin because of trespass. So you don't actually have access according to the Superior Court.
Chris,
So if anything happens relative to this property that we own, we're going to file against you for trespass. Just so you know, and we're going to be here.
So, first off, if you have a moment afterwards, I'd love to exchange contact information. I've met with Ruth before. I'm happy to talk to you. I'm going to share with the board the same thing I want to share with you because I don't want there to be any, gray area in this. Your father-in-law, who I really liked, was a nice guy, was obviously the gentleman with whom we had 10 years of litigation. This issue came up numerous times. Recognizing that you do not agree with this, we do have access rights for purposes of installing utilities in Chase Street, which is why Outback was able to go there. So we're not going to send, I just want to be clear, I have no intention of sending people onto your property without talking to you. I want to get your cell phone number. I want to have a very open line of communication. I understand your position on the project. Part of the reason we're putting this in is because we know we can't use that for construction access, and we will not be using that for construction access. And, I have no question that you'll have a number of items you'd like to raise with us, but I just want the board to understand that this is something we are very, very aware of, and as he's shared, has come up numerous times over the last decade and a half.
Yeah, well, okay, if you read the result, then you will see that we are going to enjoin against you for anything that happens on that. Alleged Chase Street, which does not exist.
Are there any other members that have anything they want to address?
262 Chase Street, Melissa Hasey. I just have a question. It sounds like they're already trespassing without permission. That's what trespassing is. Is that true?
I believe that it was Outback Engineering across our property.
Yeah, so
Surveyors have a right to trespass, it's a Mass General law, to locate property boundaries and monuments, which they were doing on those properties.
I didn't hear what you said.
We can't hear you. You have to speak up.
So surveyors in the Commonwealth are permitted to legally trespass effectively for surveying purpose villages.
Yeah, it's survey privilege, they're allowed to trespass, because if they have to find somebody's property boundaries, property markers, Mass General law allows them to go on your property to find those
If
property.
they have a permission, why is it trespassing?
It's not for surveyors.
Oh, use that word.
But it wasn't the house.
I just want to be clear. We don't view it.
No permission given
I
whatsoever.
just want to be clear. I just want to be clear. So we don't believe it's trespass because we believe they have the right.
Sounds like you did it.
Well,
Wait,
if
you
I-
guys have to be talking through the chairman.
Mr. Chair, do you mind if I just quickly, Chris Fragostino, counsel for Bruce LLC, thank you for giving me a moment. It's just, the statement that was made was that the Superior Court made a determination as to the legal rights in Chase Street, that the Superior Court made some sort of adjudication that we don't have the right to use that.
Okay.
And again, we're both characterizing a written document that the ZBA and council's more than welcome to read and interpret, but the decision was the Superior Court, the Appeals Court, and the ZBA have no bearing or jurisdiction to make that determination in the context of this 40B permit. What they said was that Mr. Sayre or the successors in title are entitled to bring an action to adjudicate those rights when we go to construct in that roadway. They may bring a separate action to try to enjoin us. What we have is a title insurance policy that ensures our access, which, the insurance company will fight that issue if they actually try to enjoin us. But I just wanted to correct that one statement, that we own access. The court did not make any determination on that. And if that remains to be discussed, I would really hope that, dialogue would continue in that sense. So happy to answer any further questions on that, but I just wanted to clarify that one characterization of what didn't occur at the Superior Court.
Okay.
Point of reference on this. You said the Superior Court did not rule in your favor, they didn't rule in your Sears' favor. Is that correct?
They didn't make any ruling on that issue.
You are making the assumption with no ruling that you have the right to do this. I have a couple of further questions.
What the Superior Court did say was that this discussion is really not appropriate in this context. It's a private, any discussion or about, private access rights is not really, it doesn't really implicate the validity of the permit or the invalidity of the permit. So we have the permit, and we went to the appeals court twice on that issue, and, I'm happy to, I would love to answer questions, but through the chair, it's, whether the chair wants to entertain
Yeah,
this.
if there's anything regarding the trespassing, it's to be taken not during this meeting. So if, I will say, is your question regarding the trespassing?
No.
Okay.
On the assumption that you're going to use this piece of land for whatever use, it's a long-term intention to have automobile traffic to get into this development, or is it just for access for utilities?
Chase Street will be used for utilities. It is not intended to be used for vehicular traffic.
Right. On the utilities, if someone can clarify this point, is Tremont Street, the houses that are on access to Tremont Street, are they part of the North Dayton Fire District, or are they Dayton Water?
I don't know off the top of my head.
And where does their electricity access come from? Is it from TMLP or National Grid?
The boundary of the North Dayton Fire District, I believe, does not extend all the way to Tremont Street.
So basically, you're giving people that live in this development or this area rights to a utility that they're not entitled to because they don't physically live in the fire district.
A separate application could be made if necessary to the Dayton Water for the Form A lots along Tremont Street.
How about the electrical?
Same utility access provisions will be addressed. We would apply with the appropriate utility.
So that's not written in
Actually, the permit has provisions for utility, and we also are going to have to present this board final utility plans as well.
Well, my point here is that if you live in West Dayton and you decide to develop and run a pipe there, you can get services that other parts of the town is not entitled to. In other words, the people that are accessing their home from Tremont Street need to have their utilities from the area that is covered by the Dayton Water District, not by the North Dayton Fire District. So you're creating a bit of a legal problem for the people that might be buying those houses because they may not have legal access to the utilities they're getting. So that's something that you need to think about.
Yeah,
A couple of other questions. Are you going to have, so there's not going to be any access on the Chase Street extension. Where is the other access to the development coming from? What off of what streets?
Tremont Street. That's
All of it?
correct. That's why we're here this evening.
Okay. Now, you said that there were houses on, when you were describing the building, that there were houses on School Street.
Yes.
Where is their frontage on that?
So if you look at the plan up on the screen,
You know, my eye is.
you're welcome to come up here and I'll show you. It's literally on School Street. Sorry, I'm not.
Is this relevant?
I don't see what the question is.
Down towards Lincoln Avenue.
See what the question is about utilities.
And ma'am, we just need your name and address for the record too, please. Ma'am, sorry, I see your name and address for the record. Your name and...
Christine Lynch, 255 Chase Street.
Okay, thank you.
Brendan Lynch.
Okay, thank you, thank you.
What is the, if this is a 40B development, obviously 25% of the housing stock has to meet affordable housing costs. And I understand that they're not going to be built the day after tomorrow, but at this point, what is the affordable rate in the area?
That will be certainly one of the conditions that will be back in front of this board, that will be primarily set, Chris can answer better than I can, by conversations with Mass Housing and the median income of the area.
So what is the timing of the construction of the 2 phases?
So to clarify, the construction of, sorry, I realize
No, that's all right.
I apologize. The construction of the homes is broken into 3.5 phases. It's laid out in the permit. I'm happy to walk you through it or provide you a copy of the permit.
Just do a short
It basically, you have to, I believe, complete the whole project within about 5 years. And again, I'm happy to walk you through the permit itself.
Give me a minute, I'll come up with some more.
I'm also happy, but this is totally fine. I'm also happy to give you
Yeah,
my number.
I want to keep the discussion relevant to what's before us.
The purpose of tonight's meeting, though, was just to get the access to what was.
Correct.
To build 3 lots that could give you a road.
Not even building lots,
No.
we're clearing lots.
Yeah, I want to be clear, there's no building permits. Do not issue building permits.
Use the wrong word.
Okay.
Lisa, go ahead.
Lisa Caledonia, Conservation Agent, Town of Dayton. 2 things, I forgot.
Yeah, so we can get it on speaker, please.
Lisa Caledonia, Dayton Conservation. 2 things. I wanted the date DEP extended the order to. You said 26, I thought, but I thought it was 25.
The DEP?
Yeah.
Oh, it's January 24th, 2026.
Okay. And then a question for Brian, or just a comment, the turtle protection plan. Are you there, Brian? Do we lose him?
No, I'm here.
Okay, the turtle protection plan, would you be kind enough to send a copy to the Conservation Commission at your earliest convenience?
Yep, we can do that.
Okay, I appreciate it.
January 24th. So if you, I think I gave you a courtesy copy of the letter, right?
Well, not the extension.
So the extension is the last couple pages of the superseding order. So if you flip all the way to the end of the superseding order, you'll see the extension. Yep.
Are there any more abutters that wish to speak tonight regarding this? Sir, Sergio?
Yeah, David Rujo, 790 Tremont Street. I've had the pleasure of meeting with the building inspector and the applicant out at the site. A couple of things I have. You know, the extension that was given by the zoning board. Are you satisfied with their layout that meets your extension?
700 feet.
I don't know what, when you extended it, I don't know what the parameters of that extension encompassed. So they're here tonight because you gave them an extension. Is this board satisfied with what they're doing so far to satisfy that extension that you gave them? While you're thinking about that, I was under the assumption when we talked a couple of times out at the site that the water and the sewer, the utilities were permitted, allowed, so on and so forth, through the Chase Street extension. Tonight, I'm not hearing that. If for some reason down the road, whatever it might be, I don't know what that reason could be because my crystal ball is broken and I can't predict the future. But if you did not get sewer and did not get water for some reason, we're going to clear land and it might not be used. And I'm not a big advocate just to, you know, cut stuff down without some type of assurance down the road that this will in fact happen. Secondly, attorney, I didn't hear your last name. Was it Chris, your first name?
Chris Agostino.
Yeah. When you said that you owned the Chase Street to bring the utilities in, did you physically buy it, or are you saying that you have a right to bring those utilities in through, and you can explain it better than I, because I'm not an attorney.
I can answer part of that question, but Chris might be able to answer it in more detail. We haven't purchased anything recently, as I mentioned to you. These rights exist under an existing title policy and existing rights that we have in the land. We have not purchased any property recently. With recognizing that members of the public here this evening don't agree with that statement.
Right, because I wasn't sure if anything was, when he said you owned it, I wasn't aware of any land acquisition that would transfer that land to you, and then, you know, you would own that to do your utility crossing, or is it, again, it gets complicated in Superior Court and so on, that you have a right to do that, but I'm just trying to get the lay of the land, no pun intended.
No, we're proceeding with the existing rights that we believe and are confident that we maintain, that members of the public, we acknowledge, don't agree.
Right. And again, I would raise the same question that my neighbor from Chase Street raised about the sewer, the North Dayton Fire District, and the electric. I'd love to be on TMLP, and I'd love to be on the sewer system, but I'm not. I'm on, you know, the other side. And I know that there's a line that runs in there somewhere, that imaginary line that I see every now and then in the woods. And where does that stop? So these lots that you're clearing on the boulevard, entrance road going in, what would they be under for utilities?
The roads, to clarify, when you refer to the boulevard, you're referring to the lots.
The access road, the construction road that you're going to construct at 450 feet, you told me that you were going to clear 2 lots on the easterly side of that boulevard.
Correct. Those lots will be served from the utilities coming through the Chase Street extension.
So those are almost in line with my home. And I am on Dayton Water, and I am on septic system, and I am on National Grid. So you're going to bring that all the way to about, you know, directly across from my home. It's got the it's got the buffer area, the boulevard. I call it the boulevard because it's the only entrance in, the only entrance out, and that was what we did back in 2003. We made it a boulevard entrance and exit. Once you get past that culvert, it runs into a single roadway, correct?
I was wrong when I told you that. The boulevard goes all the way to the intersection.
Oh, it does?
Yep, I apologize.
That's okay.
Yeah, in fairness, he wanted to tell you that after the meeting, because he flagged that for me.
But even though it's a boulevard, so I'm saying, that's why I'm referencing the boulevard. But again, those 2 lots are pretty damn close to where my residence is. You know, within my 400 feet, because I go back 400 feet from Tremont Street. So those lots will be before the culvert, and you're going to go in 450 feet. So if they're going to be serviced by TMLP and sewer, you know.
Yeah, that's why we've got a pump station here.
Right. So I'm just wondering where that delineation line is, you know. And I know that you're building this project, and I didn't have access to it at that point in time, but. You know, will I be able to have access to it? Will my neighbor on the same side of the street be able to have access to it? And the houses, or the lots on Tremont Street that you're going to clear, what did you say, there were 7 of them on Tremont Street? Those 7 on Tremont Street, what will they have access to?
Well, the sewer commission will have some say over that. We are under the permit required to over-construct the pump station.
Right. I know there was a pump station in that vicinity, but again, you know, this has been a long time since we discussed all this stuff. And again, I was under the assumption tonight that that line that runs through the woods, that imaginary line, everything to the south of that would be Dayton, septic, that type of thing. Everything to the north of that imaginary line would be TMLP, sewer system, and you know, of the water, you know, the North Dayton Water District.
The conditions of so the conditions of the permit speak to what we need to do with this board for purposes of utility access, and they are not fully defined. For example, they currently say that we're getting water and sewer from Taunton, which is not the case. So I would have to go back and look at the individual provisions as to whether or not we can perk and septic those lots and if it impacts the design, or if we would do a low pressure sewer line in there.
Well,
But
the North Dayton Water District has a contract with the city of Taunton that provides them with the water, as you know, and also with the sewer. So even though it might not be being supplied by Taunton, indirectly it is being supplied by Taunton with the contract that they have with the North Dayton Fire District and with the Sewer Commission.
Correct, yes, acknowledged.
You have to live in that district.
Yeah. I just don't know where that line stops.
Mr. Ch-
And you're creating a situation.
Guys, the side
Okay.
questions, if it's related to the access, then if it's not related to that, it needs to be discussed outside of this meeting. We can't be hearing all your side questions about past details with this project. I mean, when they come before us with actual things related to it, then sure. But, I mean, the main thing that they were talking about was the status road for the Chase Street extension to start your utilities, correct? That's the thing that was talked about with the building inspector?
But this is, we're not what we do here. If you have a practical plan, then this is.
We're very comfortable with the plan. We've actually engineered it fairly extensively. I'm just trying to respond to your statement because it's, without being rude, it's not an entirely accurate statement. I understand why it's frustrating, but we've tried to put all the information in front of the board this evening as to what we're asking for.
There will be further litigation.
Okay, guys, we're not discussing that during the meeting. If you want to take this outside after the meeting, you may discuss it with the applicant.
It seems to be relevant to what he was saying, that they plan on clearing large portions of the land without an actual plan for how to deliver water and sewer. to the-
Can I, Mr. Chairman, through you to our legal counsel, through the chairman, my question is very simple. I'm not suggesting that the homeowners and the abutters don't have legitimate cause to raise these questions. They're perfectly legitimate and real questions to raise. My concern is that right now, tonight, this is not the purview to be doing that. And my question to our legal counsel is whether or not anything that you've heard or anything else that we need to know is relevant to the decision we're talking about tonight, which is the access roadway for the purposes of conducting further testing.
I mean, I have a few questions on that particular piece that I do want to ask. I do think that there's been some legitimate comments made that brings to mind the question of, from a timing perspective, if the lots that you're clearing right now are intended to have their utilities brought to you through the Chase Street extension, what is your time frame for for following through with that? I mean, are you going to wait and do more clearing, or is that going to be your next step after?
No, we won't bring utilities down to those lots until we clear the balance of the area through which they will need to run. So it will be part of a much larger infrastructure project that we will most certainly be back in front of this board before that happens. I mean, as you simply put, those are the last two lots on the line. So obviously it's going to be a while before we'll be putting the infrastructure in there because we'll be coming in from the other side.
Marguerite, so
No,
you had
the
other
comprehensive permits condition basically says that they need to provide it through Chase Street extension, and if they can't, that they need to come back to you with a modification plan. And that is, I don't disagree with Attorney Agostino's comments around the litigation either. The litigation essentially said that that condition, in terms of dealing with the comprehensive permit, that condition addresses that piece of it. When they actually go to construct or put these utilities in, there may still be litigation that's happening. You're hearing tonight that that's very likely. You can't prohibit them from clearing this land if they own it unless there's some other provision or requirement that prohibits that. So that gets to one of my questions that I do have tonight around the clearing, which is at least my review of the natural heritage approval, and I appreciate you calling it Heritage Phase 1, Heritage Phase 2. I don't know where Heritage Phase 1 is. I didn't see a plan attached. I have no idea if that's within this area, even that you're proposing to clear. So I think it would be helpful to know that, and perhaps you have that information tonight that you can clarify. But I'm interested to know if that's fully covering this area, and then, it sounds like you've actually been doing some work to comply with the conditions. I don't think that that's actually been provided in terms of paperwork to the zoning board, but that would be useful for us to see. You know, what have you done to comply with the natural heritage conditions? Because that's something the board's gonna need some type of review of as well. Peer reviewer, et cetera.
Sure. So I'm happy to address and also point and provide information. So the October 26, 2022 approval from Natural Heritage notes phase 1 includes clearing and construction associated with the Arborcrest Boulevard entrance and wetland crossing, as well as lots 37 through 38, 57 through 59, and 60 through 63, resulting in approximately 3.05 acres of disturbance. We're not actually doing all of that right now. We're only doing a portion of it. There is also a plan which we can send that was included as part of the application. I mean, I've got a black and white copy here. It just visually depicts the area that I just talked about. And it also references the 3 conditions that we need to meet: turtle protection plan, symbolic fencing, and compliance report. The plan, we obviously maintain a copy and are happy to share a copy. I don't want to put Mr. Aguirre on the spot, but the symbolic fencing is up, and we're happy to confirm that right now, this evening. And then the compliance report would get issued at the conclusion of this particular project, or this particular, what I'm calling Heritage Phase 1.
Okay.
Yeah, you're good.
Yeah, I just wanted to follow up on a comment that you made. You know, I don't think that any member on this board was here back in 2003. And I appreciate the applicant coming in tonight, as Jim does, kind of bring everybody back up to speed to get, you know, our heads back in the game. This has been approved back in 2003. Some of the stuff I have forgotten. You know, again, they met with me out there. I've walked with them out there. I appreciate that. I really think that you, Josh, should comment on the roadway coming in the 450 feet to the culvert, so that you can do the replication in there, and then you're going to, as you told me, you're looking at possibly a building permit, hopefully within the next 2 years, so that the growth can grow, and you have restrictions and requirements to get that up and running and get that growing. So, and then while that process is going on, they will continue to go to each board within the town so that they can in fact get, you know, all of their ducks in a row. But I think that it's very important that everyone, even at home, kind of like I said, gets their head back in the game on this. This is a very big project for this town. It's a big tract of land. There's probably not many tracts left of this size. It is a 40B. You know, it's going to be helpful to our percentages in town. But again, I just think that some of the questions that are being asked, Mr. Chairman, are warranted, and, you know, we need to think about it. Again, some of the ones that I have and some of the ones that I'm forgetting would be nice, you know, just so, like I said, we all can be on the same page. I appreciate it.
And on that front, Ms. Easterday has my contact information. You know, I'm always happy to speak with the butters and citizens to educate them. They may not always be happy, but I'll always give them an honest answer.
Marguerite, did you have anything else? I just had a few things that you were...
I didn't write them down as you were talking, so I've been moving paper around, so give me a moment. So I want to clarify, I've heard 2 lots being cleared, 3 lots being cleared, 4 lots being cleared. How many lots are being cleared with this?
Yeah, sorry, that's, I can be very specific on that. We are clearing, I'll stay by the microphone. We are clearing 450 feet up the boulevard. We are clearing lots 37 and 38, which are the easterly lots along Arborcrest Boulevard. And then we are clearing 2 additional lots along Tremont Street, lot 52 and lot 58, which are the 2 closest lots to the entrance. Sorry, 57 and 58. We're only clearing 4 lots.
So 4 total, okay.
4 total lots, and then the roadway. which is within the parameters of what was approved under Heritage Phase 1.
Okay. I guess this is a question that I have potentially for the Conservation Commission agent. So it appears they've done some of the flagging work for the box turtle, which is one of the requirements of the Natural Heritage Condition. Is that something you could confirm?
I haven't been involved until now.
No, but I mean, if the board were to ask you to go out and take a look at that and provide them with a letter confirming that that's been done, is that something you have the ability to?
Well, that's
apply about?
that's what Brian Madden is hired for as an outside consultant, but yes, but I have questions regarding that as well. Is there a seasonal limitation because of the turtles? What is?
Brian can speak to that, but we've performed the necessary turtle sweeps so we can perform the construction. We're within,
But that was,
I think he sweeped recently on the replication areas. We have a
I
plan.
think it has to be right before you break ground, like he should be on site, correct?
I don't think he has to be on site when we break ground. That's the point of the barriers. He has to do a turtle sweep. Now, might he choose to be there at some point? That I can't speak to, but we have the turtle protection plan that lays out these specifics, and, you know, Brian will be the one responsible for overseeing that.
It would be really beneficial if you could send that over to town.
I mean, I believe you have copies, but I think Brian is absolutely happy to send over whatever additional materials you think are lacking. No problem.
Maybe it's my lack of understanding who Brian is.
Brian Madden is the biologist from LEC Environmental.
Okay.
He's a state certified biologist that Mass Wildlife relies on to check this stuff.
So can Brian confirm that the requirements of the condition, of the Heritage Phase 1 have been, that are required to be met before they do any clearing, have been met?
Well,
Is he on?
I don't want to suggest on behalf of Mr. Aguirre, but he's been out there and he's seen it.
So, yeah, certainly I'm no expert, but there is extensive barriers out there. They're all over the place, so they're everywhere.
With survey
Right,
stakes, it's
right.
not arbitrarily
No,
located.
I'm not suggesting it is. I just think that
Yeah,
the board has just recently received the Mass Wildlife approval letter. It has conditions in it, and there has not been, we don't have an engineer on board yet. We don't have any type of peer reviewer. So I'm just trying to find out, is there someone who is considered not just an employee or consultant of the developer who can provide that?
my recommendation would be that we use the professionals that have been provided.
Yep.
We allow the town to go forward with their peer review, which I believe is happening tomorrow.
Yes.
And then we can lean on that peer reviewer as this project progresses moving forward. But I think right now, at least in my professional opinion, and I'm not naive to the fact, they appear to have followed all the requirements that were necessary out at the site. And I did walk the site. I'm sure, and I don't want to speak for you, but I'm sure your colleague will be able to provide some type of a report for us that was indeed done, correct?
I actually think, Brian, if you want to speak, I believe you had to actually submit something to Natural Heritage.
Yeah, and just for the record, we have been out there recently to conduct turtle sweeps. We inspected the barrier, and that is all in good working order. We are in compliance with the Natural Heritage Determination Letter for the Phase 1, the Heritage Phase 1. We can provide confirmation on that.
Yeah, can you just forward any correspondence to me? I'm sure Attorney Glass will share my contact, and that way I can keep the board and our council abreast of the latest and greatest.
Sure can.
Thank you.
All right, it's 9 o'clock. We do have another item here for tonight, so if we can start to just wrap up any kind of discussions for this tonight. Marguerite, is there anything else that you wanted to address?
So I think the only other thing is that it sounds to me like the town is about to get a peer reviewing consultant.
Yes, we are.
In place, and since we're going to be moving forward beyond just this 400 50 feet clearing in the 4 lots. We probably need to start some of that legwork and getting 53G funding in place for them, et cetera. I'm just hearing about it tonight, so I don't even know the name. Somebody else might be able to give you the name.
It's gonna be presented to the zoning, to this selectman tomorrow, so I'll just wait until they
So
made the
we
final
need to wait
decision.
for that. But I want you to be aware of that, and perhaps it's things that can happen behind the scenes for this zoning board, because I agree with you, there's a lot of pre-building permit conditions that come into play here. I think you've addressed the 2 particular concerns I had that might have been more pre-construction tonight by explaining that there weren't any changes, substantive changes to the notice of intent plan from the preliminary plan, and then hearing what Brian had to say and ultimately receiving that. So to answer one of the questions that Mr. Arujo raised at the beginning about, I think it was your first question, about whether or not the zoning board feels that their extension provisions have been complied with. This zoning board granted an extension for them to begin use of the permit through the end of September of this year.
It was like September 23rd,
Right,
right?
and so this would be the type of activity that would be needed, that would need to take place for that to start.
I just wasn't sure what those parameters were when you granted the
Yeah,
extension.
there was no conditions on it. It was granted through a 3-year extension that expires, I
Yep.
believe, September 30th of this year.
Appreciate that.
The 5-year timeframe that Attorney Glass referred to does not start to run until the final plans have been approved. So at that point in time, now you're in your 5-year window, and I think that's something else that the abutters were asking about. Anything up until that approval, the final plan period, is just, there isn't anything in the comprehensive permit right now that puts a time limit on it. You know, hindsight is always 50-50. No one expected to be here 20 years later where we are, but this is where we are, and we have this document to work through and live with at the moment. And if they need to modify it, which it sounds like you will, it sounds like you've addressed some of my questions around the Taunton element, and that all pertain to a moratorium on providing water and sewer access that existed 20 years ago, again. Not a part of what's here now, but it made a lot of sense and was necessary at the time that it was permitted.
So just a reminder to the board, we don't have anything before us to be voting on. This is just mainly a status update.
I thought we did, well, not a vote, but you're gonna clear lot 57, 58, and 38 and 37, is that what I'm saying?
Correct.
The board members, any more questions for them?
I'm good.
Good, all right. So if any of the members of the public have any more questions regarding this project, I guess they can either reach out to the applicant directly, or if there's any questions that pertain to things that are brought before the zoning board. When do you guys planning on coming before us again, do you know?
I don't. I'm happy to provide
I'm gonna
quarterly or regularly updates. It's going to be driven, I think, by the pending review, which sounds like it's ideally going to be under the umbrella of one peer review engineer going forward. So as quickly as that could proceed.
So yeah, I mean, the boards that were involved submitted their recommendation to the town administrator this evening. So Wednesday, tomorrow's night meeting is when the selectmen will get that presentation and vote on to approve the peer review engineering that we're going to be using. So I would say, assuming all goes according to plan, literally this time tomorrow we'll have that answer. So at that point, Carrie can provide it, just if you were curious about the contact, who they will be. I mean, I don't want to say anything before it's official, but there is one that the town is comfortable that they're going with. So we will have that answer for you by Wednesday night.
Great, thank you. I'd like to know that, so I'll call you Thursday or email. Thanks.
All right. If that's it, we can move on to the next. You guys are all set, unless you have anything else, but.
No, thank you very much for your time this evening.
Thank you.
The next thing we have on our agenda is item 4.3, Dighton Homes LLC for Dighton Woods subdivision regarding the release of the funds under the performance agreement. So just give ourselves a second here just to get resituated. Just a reminder, our meeting is still in session, so if we can just continue any discussion outside. Just a reminder, we are still under our session. We can continue any conversation outside, please. For the final time, we are still meeting. Can you please continue discussion outside? That's for 3 times, and still continue to go on, so. 3 times I said it. How many more times do I need to say it?
Take a picture of it before you leave.
No. All right, so we have Dayton Homes LLC before us. We have someone on the Zoom who's been waiting very patiently.
There's a letter too.
In the letter, yeah.
Hang on.
Good evening, Maya Cordero for the applicant coming out of Quarry in Foxborough. I had submitted from our last meeting the documents that Attorney Mitchell requested from the applicant and from the board as well. I submitted those on August 10th along with a revised subdivision performance plan requesting the release of the full performance bond and the total amount of $52,000. I have also submitted the original signed 18th amendment signed by the applicant along with the representative from the bank, Walpole Cooperative Bank, excuse me. I believe Attorney Mitchell had recommended that the board release the funds as she had reviewed and was satisfied with all of the documents that were submitted on behalf of the applicant.
And we have a letter here from Marguerite who just sent this into us. This is dated August 10th, 2023, regarding Dayton Woods' review of the revised 18th Amendment to Performance Guarantee Certification of review of all outstanding legal documents for permit. Dear Chairman Karen and board members, please be advised that I have had an opportunity to review the revised 18th Amendment to the Performance Guarantee, inclusive of its proposed exhibits A and B. As you can see, this revision differs from the proposed 14th Amendment previously presented to the ZBA in that it involves a release of all of the remaining funds being held and thereby a termination of the performance guarantee agreement. Based upon my review, I can confirm that all work required to release the remaining $52,000 has been completed and that the 18th Amendment is appropriately drafted and evidences the completion of all this work. I hereby suggest the board make a motion to approve and execute this revised 18th Amendment to the performance guarantee and note in the motion that this approval will result in a release of all the funds and a termination of the performance guarantee. Upon such a vote, the board's work with respect to the comprehensive permit is also completed. Please feel free to contact me if you have any questions. I appreciate your confidence in my services throughout the permitting and developing process. It is a pleasure to represent the board on this matter. Very truly yours, Marguerite Mitchell, Esquire. Sounds like we have all the information that we need. Marguerite, was there anything you want to add, or besides that?
I just can't recall who the voting members are on this. Oh, Susan, Zach, and Dave.
Susan's not here. So we'll need to revise
I wonder
that.
if we changed it.
Don't think that we did.
I don't think
And that's my knowledge now.
I don't think we appointed members. I'm not sure that, did we appoint members?
No, last one was Susan, Zach, and Dave. And that was the last meeting, 2/27.
So who's been here?
And then
Who
July
was
we
the
weren't.
substitute?
I haven't missed any.
I think Elise can do it.
Has Elise been here for all of them?
You've been here for all of them, right?
I know members have missed various meetings in the past, but I'm not sure. Do they miss any meetings that this was discussed? That I don't know off the top of my head.
So Elise wasn't here on June 27th.
Oh, so that was the last meeting.
But did we discuss this in the June meeting? We did.
June 27th, it looks like we did.
Was Greg here?
Quiet.
Sorry, the connection must be bad. You guys are coming in and out. I'm not sure if there's a question being proposed to me.
Not for you. No, not yet.
We're
Sorry.
trying to
Okay, I'm
determine
sorry.
the voting members.
I was here.
We need 3 voting members, and we have 3 voting members that were assigned to this case. One of them is not here. The other 2 are. So we're trying to figure out who to put on this as a 3rd voting member that has been here for the past discussions. That's what we're trying to figure out now.
Okay.
Who were the 2, who are the other 2? Because I probably chose them.
It was,
Susan Pritchard?
Susan, myself, and Dave, right?
Yep. Yeah.
And that was done in June, is that right?
Yes.
Yeah, he was a member.
So I was here, but I was on Zoom.
Greg, John was here, but on Zoom.
Right, I have him there.
Yep.
I'm sorry.
So
Greg, you were here.
No, was Zach here on the 27th?
So do you want me to assign one other?
Hold on.
If they're agreeable?
Very good, yeah, I mean, so we do definitely need a third,
So it was, originally it was in March, and we appointed Susan, Zach, and Dave. And then when did it come back again? I'm sorry, I didn't bring my whole file, because I didn't actually envision this being the issue.
It hasn't come back, as far as I know.
I think it has. I think it has.
Definitely
It
here.
has?
I
It
think.
was always Susan, Zach, and Dave.
Right, we hadn't changed,
Dates.
we hadn't changed since those three, but the question is that, was there
We
discussion that
kept
happened since then?
continuing it, right?
So that was in March.
Okay, so that's March.
That's March.
Then,
And we had May
May.
25th, that was March, May. That was May.
no,
And
I
then
have
June.
April. We definitely continued in April. In March, we continued to April. And then in April, I may have pulled my notes out. April, we think was continued to May, so April. You signed the Mullins affidavit, Dave, for April. May. Jonathan was here in May, Jonathan was here in,
All the way through.
you weren't here in April, Jonathan.
But you weren't, I think, it looked like you weren't here in
Oh,
April.
no, you were here in April, you
Yes.
were via Zoom, yep.
Yep.
Yeah.
So then at this point, it don't make sense that John become
Where he was absent in March.
for the initial meeting.
Right.
So by that token, we can't vote on this then tonight.
And what, Greg has a conflict? Do
On
you
this
have a
particular
conflict?
Well, so it's a zone, it's a 40B, I think you only need a majority vote. So I think you can vote on this,
With two members?
2 members.
So as long as one of us.
As long, but doesn't the applicant have to agree to that?
No,
No.
it's a majority vote, I mean, you'd have a member who's not present who,
So we have two, as long as one of us doesn't disagree, then it's a majority.
this it doesn't require a unanimous vote.
I mean, I've been here for all the meetings, just wasn't voting
Greg's
on
been
it.
here.
But Greg, do you have a conflict? Or is this not the one you have a conflict for? Well, then.
Not with Dighton Woods,
No.
right?
I thought it was.
Then
Across
if
the
that-
street.
I thought
Sorry,
it
I was
was.
thinking you had a conflict.
No.
That's
I'm
fine.
sorry, I thought he did too, that's why I didn't say
Okay,
anything.
well then if Greg's been here, that's just to be safe, let's just substitute him.
Okay.
It's your choice.
Sorry, Greg,
So-
I thought you.
I thought you did
It's
too,
across
Greg.
the street.
I will appoint Greg.
That's right.
Greg is the third member.
Okay, thank you. Okay, so now we have that, how do you guys feel, Greg?
I feel that,
Wait, you have to actually take a motion to substitute Greg.
Oh,
So you
sorry.
and Dave have to make a motion to substitute.
So I'll step down a chair for the point of making this motion that we substitute Greg as a voting member for this case for Susan Pritchard, as she's not here today to make this case.
Second?
Any discussion? All's in favor? Aye. Dave, are you an aye?
Aye.
Thank you. Okay, so Greg, you're on.
I'm up.
Yes, you're up. Yeah.
All right.
Any comments?
No, I feel they've met their requirements on all the paperwork that's in the file here, and I don't see any reason to hold any more funding on them.
Okay, Margaret, is there anything additional you want to add? Or, I mean, you'll let our note speak for itself, but was there anything else?
Just, I want to just be clear in my letter that when you make the motion, that it has to have not just a motion to approve, but there's an element about that you're acknowledging that by approving this release of this bond, and I worded it the way I suggested the
Yep.
motion read.
So
But
you get to
essentially,
read.
it's the final release.
Okay, so I will make the motion to approve and execute this 18th amendment to the performance guarantee, and also that this approval will result in the release of all the funds and the termination of the performance guarantee agreement. And that will, and that will also Sorry, just with respect, also that the comprehensive permit will be completed.
Second.
Any discussion? All those in favor? Aye.
Aye.
All right. Let's approve, you're all set.
Great, thank you so much.
That smile was enough, we're good. Okay.
Should I reach out to Carrie to obtain the original, because I do need to record it?
Yes, please.
Great, thank you, have a great evening.
You too. Okay, is there any public input? Nancy and Jim look very tired. All right, do we have any additional correspondence? Before we get, so next thing is the approval of the meeting minutes from July 25th. I just want to make the record that in that during that meeting, we made a reference to that apartments in general would be counted towards the 40B stock for the town. I have since been told that the information given to me by Chairman Karen is incorrect. It's only if they're affordable. If they're market rate apartments, they don't. So he told me that by default, all apartments counted toward the 40B stock. Marguerite has told me that they don't, only if they are affordable. But if they're market rate, they do not, right?
So if it was a 40B development that had apartments
In it, then
all apartments would count towards your
Not just
housing
any-
stock.
not just any
Market rate
apartment.
and affordable. But because this isn't a 40B
project.
or doesn't otherwise meet other thresholds or options under, that would allow this to count, it's not just an apartment in general.
Right, and that's what we thought at that meeting. So I just wanted to make clear that we can't amend that. We can't amend the meeting minutes because it's what was said and what was done. But we just want to make sure that that piece of information in there was not accurate. That's all.
So in this month's minutes, you can have it, you can indicate that you want to revise, you want a revision to last month's minutes, and that you want the last month's minutes to kind of have an asterisk that indicates that there was a revision made to that comment.
So can we approve these minutes pending that change happen, or just not approve?
Just approve those minutes with the condition that the asterisk of correcting the incorrect statement.
Okay.
be added.
So I'll make the motion that we approve the meeting minutes from July 25th, 2023. Once the error has been completed about the, corrected, sorry, about the apartments being 40B for that development.
So moved.
Any discussion? All in favor?
Aye.
Aye. Is there a motion to adjourn?
Motion to adjourn.
Any second by Elise? Any discussion? All in favor? Aye.
Aye.